Pronouncement of judgment, item 17.
Apply.
For judgment, item 18, WPC 1681/2025.
May please, Lordship. My lord, item number 5. Yesterday, I filed a request for adjournment, Lordship. Item number 5. Deeply obliged.
Lordship, item number. Lordship, yes. Lord. Yes, Lord. Lordship, item number 3. Lordship, my senior is not present today due to his illness. Item number 3. Kindly adjourn the wait. Okay.
I'd like to mention item number 8, possible for the day.
Item 19 will be called after some time. Now, item 1 for hearing.
May please. The informed judgment, opinion, my lord, is 66. The document which was annexed by the petitioner, my lord. Page 66 from last, voter list of 1966. Voter list of 1970, final Patian, voter list of 1985, voter list of 1997, 2016, Kabinnama affidavit, Baupunshad certificate and per identity card. And beside this, PW2, the brother of the petitioner, he also exhibit the following the documents and which is the executive manner. Electoral voter ID card, voter ID 1980, character certificate, permanent residence certificate, link certificate, and job on the copy. This is the document which is the next, my lord. Now, next, my lord, the decision and reason there. Job on the, my lord. Page 40, yes, page 44, my lord. 4. And the part 45, vernacular part, my lord. 45, vernacular part, my lord. So, may I read, my lord? My lord, written statement, my lord, is 47. Written statement, my lord. And 47 to onward, my lord. This 48 additional.
Please proceed.
And my lord, I am reading from page 67.
You're reading from?
67, my lord, from the opinion.
Yes, Mr. Ake.
My lord, decision and reason thereof. In the case of the prosecution, the witness has been examined, but to prove herself to not be a foreigner, the OP submitted her evidence on affidavit. In her affidavit, OP stated her father name is Afsar Ali and Ansar Ali, Alliance Ansar Ali, and an Afsar Ali, and Afsar Ali. And his father name is recorded in the voter list of 1966-1977, Exhibit 1 and 2. OP stated her father obtained the penal Patian in the year 1962, Exhibit 3. OP stated her father purchased a land in his native village in the year 1962, had registered salary number, so Exhibit 4. OP stated that her name recorded in the voter list of 1985, 1997, 2006. Exhibits 5, 6, 7, and 8. OP stated that she married with Adam in the year 1970. Register Kabinnama, Exhibit 8, who is named recorded as Nurjan and Inspector Nurhana. And in this regard, issue sure an affidavit and Exhibit 9, which is stated that he obtained the consent certificate by the Secretary of Province, Exhibit 10. OP stated he obtained the voter identity exhibit 11. To come just conclusion, let me appreciate the evidence on the record along with the appropriate document to determine the nationality of the opposite party. From the record, it appears the opposite party projected answerably as her father, whose name recorded in the exhibit 1 and 2. This voter list in the respect of 1966-1976 pertain to the list of popular Maspara. Under Ovoivo the name of the answerably is recorded and the some other voters. Exhibit 3, the final written in the name of the Ansari and the Iman and Iman Ali. As per OP, her father and her name and recorded Afsar Ali as Exhibit 4 and regard in a is a register sealed dated 23/12/1963 in the name of Afsar Ali Mia. In the stated that her father name purchased a land. In the exhibit 5, 6, 7, which are voter list of 1985, 1997, and 2026 of Bolis Kupula Utturpara. As per her name is recorded with her husband Adam Ali. These voter lists are not relevant established the linkage with Ansar Ali and Afsar Ali, and whom the OP claimed her father. Exhibit 9, Exhibit 8 is the marriage Kavinnama between Nurjahan Begum and Afsar Ali and Adam Ali dated so and so, which rendered in itself the inadmissible at the same was not being proved as per procedural law. Exhibit 9 is the affidavit shown by the OP and explanation discrepancy her name. A sumo moto affidavit is neither the proof or evidence as per section 1 and 2 the evidence of 1972. 72. OP stated that she obtained a Gaupancha certificate at Exhibit 10 issued by the Secretary Palbari Simlabari Gaupancha on 26/2015. She and the author of the said certificate were not examined therefore the tribunal continuously reported the certificate and eventually thereof the document no way considered as a linked document. As so far voter identity card in identity card 11, the photo identity card is concerned, besides not being proved, it is the post of 25/3/1971. The document it has been held by the Honorable Supreme High Court.
Please look at these records.
Lord.
You see, please come to page 52. This is the evidence,
Yes, Lord.
correct?
Hmm.
And after these few pages, you will find the documents.
Yes.
Correct.
Hmm.
These are not the original, and the photocopies are not signed by the tribunal. And yet here the tribunal has considered those. So we'll have to send it to the tribunal so that the petitioner can produce the original and it has to be signed.
Lord. Yes.
And in the order sheet, you look at the order sheet, there's no order either to exempt the production of original or to return the original. Well, Mr. Ali, the originals were not produced. So even your very good argument would get diluted. Look at the documents, you will come here and look at the documents. Do you have the original documents with you? Is it signed by the tribunal?
I have exit all the just signed, my lord. I annexed the document, all are the signed, my lord. All are the signed, my lord. Kindly see, my lord, one more place. Exhibit that are the signed by the from page 16, my lord.
Page
Page 16, exhibit minus 1.
16.
That was written by page 16. Voter list of 1966. Tribunal mark, my lord. And it was
No,
signed.
there is no sign of the tribunal.
But there is no sign of the tribunal, Lord.
It doesn't have the.
Yes,
Yes. The documents are exhibited, but sign is not there, Lord.
Then I think that happened.
So Lord, could-
So this is irregular. We'll have to send it to the tribunal so that it can sign it and send it back.
Yes, Lord.
Mr. Ali,
Yes.
you can please go out, have a talk with your with the petitioner or family members, and because we propose to give a date for the appearance of the petitioner before the tribunal to get the original documents produced and signed by the tribunal. Please communicate and tell us.
Matter may be kept pending, Lord.
We are keeping
Yes,
it pending,
yes,
but it has to go back.
And it, my lord. My lord. September, my lord.
Just ask them to come back after 5 minutes
Yes, ma'am.
to tell us after contacting them.
Yes, ma'am.
We are proposing to give a date.
If
The
you
first
will
week of
contact any date fixed by the honorable court, they will be over, my lord.
No,
Any
no.
date, my
We don't
September.
want it to be missed.
Yes, ma'am. Then I,
If we fix a date, we want it to be complied with,
yes, ma'am.
so that the records can come back.
Yes, ma'am.
So we are proposing any date within the first week of September.
Last,
Whenever it is convenient for them, we'll fix that date so that the records can be sent through the through Mr. Sharma, through the Home Department, so that it can be signed and sent back.
yes, my lord.
Just communicate
Yes,
and
yes,
tell
my
us.
lord.
We'll take it after some time. When you come, we'll take it up.
Supply item 19 for motion.
Yes, please, your lordship.
My lord, he was declared foreigner, petitioner husband was declared foreigner. And husband filed a writ petition before this honorable court, and that has been pending. And at the time of filing of the writ petition, he was in custody. The affidavit supporting the petition was sworn by the one of the brother of the
Okay, we'll dive into, tell us the whereabouts.
Mile.
Uh,
Heard Mr. A.R. Sikdar, learned counsel for the petitioner, also heard the learned counsel for the respondent. The petitioner has submitted that her husband, Sonali Ali, alias Sonali Sheikh, was taken into custody on 21/5/2025 and by the Choigaon police, and thereafter has been shifted to Matia Detention Center, Gwalpara on 25/5/2025. Accordingly, thereafter the whereabouts of the husband of the petitioner is not known, and this petition has been filed under Article 222 of the Constitution of India. From the materials available on record, it appears that that the petitioner, or that the husband of the petitioner was declared a foreigner of the post 25 to 1971 period by an opinion rendered in GFT within bracket R, case number 413 of 2017 by the learned member, Foreigners Tribunal number 1, Kamrul Rural, Ulubari, page 4, para 223. On 12/1/2018. Thereafter, the husband of the petitioner had preferred WPC 2813 of 2018, which is stated to be pending. As the petitioner projects that her husband was taken into custody and his whereabouts is yet not known, we request the learned standing council, FT matter, to obtain information as to the place where the husband of the petitioner is now lodged.
Yes.
And whether he has been already deported. And if the husband of the petitioner has been deported, we shall produce information as to the place from which the husband of the petitioner was deported and the manner of deportation. The learned standing council for the FT matter is permitted to send a downloaded copy of its order to the concerned authorities to enable him to obtain information and inform the court accordingly. List on
18th, Lordship, all 18th. All related matters are coming on 18th. Yes, Lordship.
Go
Yes,
and
Lord.
take signature and then make, you can fix it on that day, but prior to that, you get an information. By when?
Okay. Minimum 4 days time will be required, Lordship.
Okay,
4 days,
so fix it on 13th of August.
Lordship.
After
And
that,
copy
we'll
of the
fix
petition may be served, Lordship.
Will sir.
extra copy and then
Yes, sir.
soft copy also, because he'll have to send it
Fine.
by email.
Both will sir.
During the course of the day.
Yes. Hard copy আছে না আপনার?
Yes.
But
Even I will be soft copy. Okay. Copy. Just.
learned counsel for the learned counsel for the petitioner undertakes to serve extra copies of the petition to the learned counsel appearing for the respondents,
In course
as
of-
well as soft copy during the course of the day.
Please, sir. Madam, sorry, last week, any day September, it takes September, last week of September, any day, ma'am.
Last week of September.
Yes, ma'am. September,
Last week of September will be too long. We are now in August.
August, my lord,
Huh?
August 8th, my lord, now. Now August, September, second
Sep-
week. Second week.
Second week September, okay.
All the
What do you know?
certificate copies are available. All the certificate copies are available with them, Lord.
No,
Only
that's
the
why
place
they
He
before
will
the
lost
tribunal,
it,
Lord.
then he will lost it.
It's okay, he has
Ah.
taken consent. Uh, In this item one, all sides are duly represented. In the matter has been listed for hearing, and in course of hearing, it is noticed that along with the evidence on affidavit filed by DW1, you notice from the records of the tribunal, and the only photocopy of the exhibited documents were produced. Full stop. However, the learned tribunal has discussed the exhibited documents in the opinion impugned in this writ petition. Full stop. With the assistance of the learned standing counsel for the FT matter, Mr. G. Sharma and the standing counsel for the FT matters, the records were produced, but the original exhibits were not found available, and there is no order by the learned tribunal of returning any exhibited documents to the DW1. Next, under such circumstances, we direct the petitioner, namely Nur Bhanu, to appear before the foreigners, before the learned member, foreigners tribunal, Bongaigaon number 2 at Abhayapuri on or before 10/5 at 10/9/2025, and by producing a certified copy of the order as well as the original exhibited documents, and produce those documents before the said learned tribunal. On such production of original exhibited documents, the learned member, foreigners tribunal, Bongaigaon number 2, Abhayapuri, is requested to put his signature in the exhibited documents so as to authenticate the same. And the original documents as well as the records which are being sent back shall be returned back to this court through the Home and Political B department and the concerned Superintendent of Police, Border, Bongaigaon. Next para. Court is inclined to hand over the records of the said BNGN, they said BNGN oblique FT-2 oblique APR oblique case number 346/16 arising out of reference number at page 66. It was disposed of by opinion dated 6/8/2020 to Mr. G. Sharma, the standing counsel for the FT matters, FT and border matters. So as to send this head record to the learned tribunal through the Home and Political within bracket B department for signature of this signature of the learned tribunal on this exhibited documents. Next, public tribunal shall send back the records as indicated above. Next, list the matter on list. List the matter on 16/9/2025. Before that, you say, the standing counsel for the FT matters is permitted to send a downloaded copy of the order to the concerned authorities in the Home and Political, which is the B department, to do the needful.
Hello.
Understood, because if we don't do it, then we'll have to dismiss your writ petition for no reason of yours. Case was not correctly handled by the counsel. He should not have allowed an unsigned copy to remain on record. He was not careful.
Item 2 for hearing.
In this case, my lordship, relevant portion of the judgment is start from page 36, my lord. Sorry, 34, my lordship. Sorry. Page variation is
You see, please come to page 38.
Yes, my lord.
Now, paragraph 4, the tribunal says that you have given 10 documents, out of which 6 exhibits are for drawing relationship with Abdul Karim. Now, this 89 and this 1993 are of a different village.
I have already submitted with regard to this in my written statement that for better life purpose, kindly come to my written statement, my lordship, and also in my writ petition also. Kindly come to page 29, my lordship. Para 10 and page 30, para 12.
But then also you, even if that is accepted, then also you are connecting also, you see the voter list of page 1989 is at page number 17.
Oh, Karim, name difference is there.
No, that's okay. But you see this, Karim is your father. How do you, this Karim, who was the voter in another village, how do you connect him to be your father?
Also, we 85 moved there, my lordship.
Hmm?
In 85, maybe we have moved to that village, my lordship.
No, that's okay.
Okay.
But you see, B is a voter in village Z. You are a voter in village A. You are A and you are a voter of village Y. Correct? We are wanting to ascertain that A is the son of B. That's the issue. So merely because the name matches, whether he's a father or not, that has to be ascertained. But that is the only issue, how you have connected yourself to your projected parents. Because in these cases, the little experience we have gathered is that the names are very familiar or similar. So therefore, if there is any document, just like, for example, you have said, there is a document here, which is the Gaon Panchayat certificate. Then Exhibit 7 is a Gaon Bura certificate, but those were not exhibited by the concerned author.
Then Annexer 8 is Jamabandi copy.
It is Gaon Panchayat certificate, I believe.
Annexer 8 in my document, page 23.
No, we go by the exhibit number.
Okay, sorry.
Exhibit, because that is more,
Yes, exhibit 8 is Gram Panchayat certificate.
that was not exhibited by calling the author.
Even if my lordship, it is not called that particular Gaubura is not been called, but tribunal has the power, my lordship. They can summon, my lordship, have the power, they have the power of the civil court, my lordship.
No, you see, you have done more cases than we have handled. So therefore, we expect that you also know the law that our High Court has laid down, under what circumstances the court will summon a witness. First, you must give a requisition. If they don't come, then you move the tribunal to use paragraph 4 and then summon it. So you'll have to demonstrate that you took steps and that he did not come and the tribunal did not accept your prayer to call for the witness. And then you see the tribunal has found a hole in the deposition, in the appreciation of evidence. That is, you'll find it at page 39. From somewhere in the middle. If these 2 years of birth of Nurul Haq are compared, then one will find a difference of 8 years. Hoping they said deposition has crossed and said the names of 4 brothers. This is not disclosed in the written statement. It's interesting to note that if the mother of the OP died in 1980, as per deposition in cross, then how can Rushma Begum be the sister of Kamrul Haq, be the brother of the OP, because Rushma Begum was born sometime in the year 1983.
Their age
And-
variation is there in voter list, my lordship. Regarding which due to which in all whole of the cases, my lordship, especially based on the age variation, even with this father's name and his mother's name.
No, this is not a discrepancy in age. This is your deposition. You say that the mother died so and so, and then you say the sister was born in so and so. How is that possible? It's not a case of discrepancy. Because this is a specific year of death. It's a specific year of death. So the other alternatives can be then you have a second mother or you have been adopted. The sisters could have been adopted, but that's not your pleaded case.
My lordship, I will look into that.
Hmm?
I will ask him that whether second mother is there or not. In this case, my
No, now there will be. Once you ask, you say that it will be. It's very easy to say that X was the mother. He was alive for 4 years, gave birth to 2 children and died. Because the pleadings are not there. It's not a question of denying you an opportunity. We can give you to have an explanation of what has been pleaded. We may not be on the same page with the tribunal when insofar as the certified copy of voter list is concerned, but that is immaterial because on facts, you otherwise have not been able to
that
prove anything.
in all voter list, my lordship, my linkage apart from all these things, all in all voter list, the linkage were properly shown. And it was also been stated that his elder brother, that Javamandi copy used, kindly come to page 42, my lordship,
42.
42. And his elder brother has also given as a yeah, that, and till today, no, he's been Indian, and only that his brother, another brother, that means me, Barul Haq, is foreigner, my lordship. Lordship may kindly come to Jamabundi part, my lordship, page 23, annexary. My lordship, para 12. Paragraph 12.
In this Jambavati we are showing, which is the serial number of your, of the petitioner?
My lordship,
The Jambavati exhibit 10 you were showing us, which is the entry of the petitioner? Name of the petitioner is is at which serial number?
13. I have given the type for you. Page 25, Badrul Haq, 13. Type the original one. I need a type copy, page 23. And his brother name is at 15.
regarding re- uh,
Yes.
Regarding my lordship, that lordship has asked first question that how the Badrul Haq, the same, how can he be the same father, my lordship? Apart from them, all the names, including his grandfather, plus the one person at page 16, voter list of 1989, Nurul Haq, everything is same, even if the village is changed, his grandfather's name, his own brother's name, then his father's name, father's grandfather's name, everything is same, my lordship. Not only his father's name. He moved from that village in 1985, my lordship. 1989 voter list in a different village, my lordship. And Nurul Haq is one of the, my lordship, one of the brother who is given DW2, my lordship. Until that, he remained as Indian, my lordship.
When is your, when does your name first appear in the voters list? Which voter list your name first appeared?
As per here, my lordship, 1989. When we moved from that village. When I was 20 years old, my lord.
Then your name would not have been in the voter list because the age of franchise then was 21. It became 18 when?
Since 1989, it becomes 18 years. Lordship.
1989, yes,
It
ma'am.
became 18.
18.
Oh, so therefore
Prior
his name.
to 89, Lordship, it was
Okay, then his
21.
name is rightly there. कितने क्यों हुए इसमें?
আমাদের একই রাউন্ড ঠিক আছে সেকেন্ড রাউন্ড কখন তাহলে এটা কি হচ্ছে এটা স্কুলে কথা এটা দুটো রাউন্ড লিখে গেছে এটা আমাদের না the 1989, with regards to 1989, my lordship, all the money, including his brother name is also appeared, same. Father's name is also same, grandfather name is also same. And his name is also appeared, my lordship. And again, in the year 1993, again, he shifted back. And this was also stated in the, in our written statement, my lordship. And at that time, in 1997, I think he was declared as the voter. All the linkages were shown, my lordship, including in the Jamabandi copy, my lordship. And the brother who given the testimony, the testimony, he is also Indian, my lordship. But exactly, maybe they
Brother,
have.
you have not pleaded. Brother, we may have to omit. Brother is something which is not there in your pleading. Yes, Mr. Sharma,
Lordship, there,
89 shows his father and the petitioner together.
Lordship. But of different village, Lordship, that was.
Maybe
not-
different village.
Yes, Lordship, and Lordship, I think Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship. And Lordship, except this footerless Lordship, petitioner is no way connected, Lordship, with his projected father. Lordship, and WS totally inadequate, Lordship, and Lordship, one important thing, Lordship, when his father died, Lordship, that was not mentioned, Lordship, in anywhere, Lordship.
It is mentioned, my lordship, in the first, I think, in the year 2003.
In WS, it was not
Oh, no,
mentioned.
no.
And Lordship, what Jamabandi document has been exhibited before the tribunal, Lordship, it is in the year of 1996, it was Lordship, by way purchase, Lordship, her name was inserted. Family's name was inserted in by the order dated 3/9/1996. So Lordship, that cannot be accepted as a valid piece of document for proof one citizenship, Lordship. And Lordship, what
No,
footer
this man is a male,
yes, Lordship.
so he's referring to his own name. That is,
Impugn opinion, Lordship, reflected,
that is an entry of 2017 after the reference was made.
yes, Lordship. Yes, absolutely, Lordship. And footer list is not sufficient to prove one citizenship, Lordship. And on earlier, many occasions, Lordship, we are submitting this judgment, Lordship. Aziz Mia's case, Lordship, what it says, Lordship. Para 14, Lordship. WPC 2370 2023. Para 14, Mayor it, Lordship, Para 14. Aziz Mia's case, Lordship. Aziz Mia 2370 2023. WPC. Lordship AZIZ alias MD AZIZ WBC 2370 2023. Para 14, I am reading Lordship. We are constrained to observe that a mere claim by a suspected person by referring to a voters list claiming a person therein to be his father is not a conclusive proof. WBC 2370 of 2023. Two three seven zero 2023. Paragraph 14 Lordship. We are constrained to observe that a mere claim by a suspected person by referring to a voters list claiming a person therein to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voters list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. Here in this case, Lordship, proceed exhibited Gaon Panchayat certificate, Gaura's certificate, Lordship, nobody come before the tribunal to depose on behalf of him, Lordship. And Lordship, no, Lordship. Lordship, and here, Lordship, all the discrepancies have been clearly discussed by the tribunal, Lordship, in this case, Lordship, regarding age discrepancy, name discrepancy, all these things are discussed in the opinion, Lordship. So, in my view, Lordship, this opinion is good, Lordship, in law. Lordship, 1966 voter list of Ah Korim, Lordship, single name voter list, Lordship, and next voter list is of 1970. This is also Ah Korim, but Lordship, his projected mother's Rokibun Nesa's name reflected in the voter list of 1971 as wife of Korim, not Ah Korim, Lordship, in page 14, Lordship.
And that we may not take a very serious note of.
Lordship. Then, and reveals that this Rokibun Nesa mother, projected mother of the Procedural Lordship, she died in 1980, Lordship, but after 1971, Lordship, there was no continuity in respect of mother of the proceeding. Apart from that, Lordship, since 1970 to 1989, Lordship, there is also a lack of continuity, which is very essential to prove one citizenship as per section 682 of the Citizenship Act, Lordship.
So far as mother is concerned, we find there is a link. These exhibited documents, that voters list of
Only
1970,
71,
71.
Exhibit 3.
Yes,
only 1971.
page 15. This Rokiban Nasa, you will see house number 56. Karim is there.
Yes, yes, no.
And then Rokibun Nasa.
And Lordship,
Page 11. The voter list of 66.
yes.
Is
I have
Abdul
seen
Karim is house number 56.
Yeah.
Voter list of 1970 at page 13 is again house number 56. There's some connection.
Yes. Up to that extent, Lordship, there may be some connection, Lordship, but after that, Lordship, this 1989 footer list, Nurul Haq's name appeared at the age of 31, Lordship. But prior to that, his name was nowhere reflected, Lordship. And here, if first time reflected, Lordship, projected brothers of the proceeding, Lordship.
Where was it written statement?
At page,
20.
starting from page 28, annex 10.
28. Any statement anywhere when your father died?
I have mentioned in my, any statement I have mentioned in my, kindly come to first page, my lordship, synopsis part.
No,
No, in written statement, my lordship.
Written statement or evidence in chief or wherever,
I
is it before the
could
tribunal?
not find lordship.
Not there.
I could not find lordship. You can- Only oral statement is not enough lordship. Vijayada case that state lordship. This lordship in para 17. It has said that lordship, it is tried that mere filing of detention statement and oral testimony in a proceeding under Foreigners Act would not be enough. The fact in issue would have to be proved by the proceeding by reducing documentary evidence which are admissible and relevant.
You are reading where?
Vijay Das case lordship, para 17 lordship, 2018 3 GLT 118.
Bijoy Das.
Yes. 2018 3 GLT 118.
2018,
Yes, lordship, 18.
3,
GLT 118. Decided on 18/4/2018.
what does it say? Paragraph?
Para 17 lordship. It is tried that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceeding by reducing documentary evidence which are admissible and relevant, lordship. Here, lordship, apart from voter list and oral testimony, lordship, there is nothing, lordship, no way connected the proceeding which is projected further, lordship. And regarding voter list, what Aditya case says, lordship, I have already submitted, lordship.
My lordship, in this case, along with the father's name, there is a continuity is there, my lordship. And with regards to their Jamamandi copies are there. Yes, in the Gambura, their state emblem was used, but it was not a petitioner's fault, my lordship. It was used by.
I know.
And regarding my lordship section, he said Citizenship Act 1955, my lordship. Subsection 2 clearly states that all the person Indian or who came on 1st January 1966, specifically including such of those whose names were included in the electoral roll used for 1967, and those who are ordinarily resides in India since that date entry shall be deemed to be a citizen of India. My name is there in 66 electoral roll. Oh, sorry. And if required, my lordship, then with regards to Rakibul Nisa, we can bring, if the voter list are there, we can bring out all those voter lists and it will be sent before the tribunal. And regard to 2003, there will be a Kabristan, if his father has died, then there must be a report with regards to a death certificate, my lordship, given by the Kabristan. If it is been taken, it can be given before the tribunal, my lordship. And regarding age discrimination,
Post lunch. Sorry, we'll take a short break and come back.
My lordship, I want to,
You were making some statement with regard to the voters list, name of the voters list, what we were referring to last, when we took a break. You were referring to 1966 voter list, for what reason?
no, I'm saying that his name was continually there with his father's name, my lordship. From 1989 onwards, my
So
lordship,
1989 on.
onwards, and 1966 onward, his father's name is there. And kindly come to page 30, para 16, my lordship. Although it was not stated that when his father was died, but which year his father was died, but it is written that the father of the opposite party had a plot of land under Jagiju Moja, Kobhar, under Dag number 5, Patna number 32. After the date of the father, opposite party of the said land was mutated in the name of the opposite party and his brother and sisters. And with regards to that, I want to add that, my lordship, whenever there is a Jamabandi is there, my lordship, certain records with regard to date of the date of the deceased has to be given, my lordship. So surely they have given after date only their names were being. It was not said which year he died, but it is been given that his father in the written statement, my lordship.
Which was the entry of your father?
Yes, my lordship.
Page 24, which is the entry of your father?
Page 24. Number 3 is his father's name, Abdul Karim, that was struck off. Page 24, number 3. Pita Hazir Ali. Deleted.
It was not inherited, my lord.
Hmm?
It was not inherited, my lord. 2009, in the year of 2009, it was purchased. Lord.
Where you are reading?
In Montebello column,
Hmm.
I think Lordship Go. কবিতা দখল সূত্রে not eligible. Lord.
No.
No, Lordship. No. No, not contained, Lordship.
Then how is God relevant?
Irrelevant, Lordship. Not
Irrelevant.
relevant. Not relevant, Lordship. This part.
No. Serial number 3 is Abdul Karim.
Yes, Lordship.
Pita Hazir Ali. In
Lordship.
that Potadar Nam, Pita Nam column, you see?
Mm.
Serial number 3, struck off Muhammad Abdul Karim, if I'm reading it correctly.
মৃত আব্দুল করিমৰ স্থলত
Pita Hazir Ali. So Abdul Karim was not Pune, who has come. Will be a different issue. Abdul Karim is there in the original.
but before that, Lordship, খৰিদা দখল হতে হতে that means, Lordship, it was opened by way of purchase, Lordship, not inherited land, Lordship.
No, you see, that is only for the purpose of corroboration,
Yes, Lord.
that the name of the father is there.
Yes.
He's trying to link himself with his father. This is a
Yes.
link document.
Lordship.
The link document, even if it is later, then the link is established.
You're Mr. Day, right?
TK Dev.
TK Day. You come to page 24. Page 24, right? The last part. Can we read it? Sokro Bikoya.
চক্র বিষয়ে 29/1/2017 তারিখ নামজারি HOJ 2017.
Right. Now, if you come to page 23, this is disturbing us. The remarks column, right? You have the remarks column?
Yes,
In pursuance of the order passed by the circle officer in mutation case number, where is that date in the translated book?
that 29/1/2017.
And someone has also
So, brother-
certified it to be a true copy while filing the matter.
Because I think mistaken.
Therefore, the certified to be true copy, there cannot be a mistake in these translations.
Yes, ma'am.
When we cannot reach the English version, we have to go for the vernacular version all the time. Because there are judicial orders of this court where one is required to certify that it is a true translated copy and that responsibility has to be taken. by someone. See, matters come here because there was something wrong in the tribunal, it was not properly conducted.
Yes.
Here, if it is not properly conducted, where do litigants go? That level of responsibility has to come up here.
Yes.
This is not your certificate, okay, I think it's some Mr. N. Islam.
Yes, ma'am.
Once we say that this is not a correct translated copy, the entire thing will be difficult.
And from this copy, Lordship, it cannot be ascertained that the father of the proceeding occupying the land since 1966, Lordship. Possessing the land, Lordship.
Intention is to show the link. Year of taking possession is not the issue here.
May I read 2 lines from one typo?
We are in fact sad to say neither the case was well conducted in the tribunal, nor it is well conducted here. See page 95. It's a casual attitude. चलता है. See page 95, read that. 95 and 99.
মোৰ নাম বদুল হক, মোৰ দেউতাৰ নাম মৃত আব্দুল কৰিম, মই সিদ্ধাৰ্থৰ পৰা গাঁৱত থাকো, জগা থানাৰ অন্তৰ্গত, মোৰ বয়স 45 বছৰ। মোৰ মাৰ নাম মৃত ৰকিবুল নেতা, ইংৰাজী 1938 চনত মোৰ মাৰ
This is the classic example of confirmatory cross-examination.
মোৰ মাৰ নাম মৃত ৰকিবুল নেতা, 1980 চনত মোৰ মাৰ মৃত্যু হয়। মোৰ দেউতাৰ মৃত্যু 2003 চনত সিদ্ধেশ্বৰপুৰ গাঁৱত হয়। মোৰ মা দেউতাৰ মৃত্যুৰ প্ৰমাণ পত্ৰ মই এই গোচৰত দিয়া নাই। মোৰ দেউতাৰ জন্ম সিদ্ধেশ্বৰপুৰত হয়। মোৰ দেউতাৰ জন্ম প্ৰমাণ পত্ৰ দিয়া নাই। মোৰ দেউতাকৰ নাম মৃত হাজিৰ আলী। তেখেতৰ জন্ম ক'ত হয় মই নাজানো। তেখেতৰ মৃত্যু সিদ্ধেশ্বৰপুৰতেই হৈছে। তাৰ কোনো প্ৰমাণ পত্ৰ মই এই গোচৰত দাখিল কৰা নাই। মোৰ জন্ম সিদ্ধেশ্বৰপুৰত হয় আৰু ইয়াৰ প্ৰমাণ হিচাপে গাঁওবুঢ়াৰ প্ৰমাণ পত্ৰ দিছো এই গোচৰত। মোৰ দেউতাই 1963 চনত ভোট দিছে, সিদ্ধেশ্বৰপুৰৰ পৰা দিছে। দেউতাই 1970 আৰু কেতিয়া দিছে মই পাহৰি গৈছো। দেউতাই সিদ্ধেশ্বৰপুৰৰ পৰা আৰু উৰ্ধ গাঁৱৰ পৰা ভোট দিছিল। উৰ্ধ গাঁৱত 1998 চনত মই আৰু মোৰ দেউতাই খেতি কৰিবলৈ যাওঁ। উৰ্ধ গাঁৱত থকা প্ৰমাণ পত্ৰ
Now you see that's kheti koribo jao, just stop there and come to that Jamabandi. It is before that. Yes, in your hand that, yes. Look at the class of land, Laitoli, Salitoli, correct?
Lordship, yes.
So that's a land where ideally you can have this paddy field, correct?
Yes,
Now come back to your what you were doing. Whatever was not there was all filled up.
Lordship. উৰ্ধগাঁৱত থকা প্ৰমাণ পত্ৰ হিচাপে ভোটাৰ তালিকা এই গোচৰত দাখিল কৰিছো। মই ভোট দিছো 1998 আৰু 93 চনত উৰ্ধগাঁৱৰ পৰা ভোট দিছো আৰু মই ভোট দিয়া নাই। 1997 চনত মই ডিপুটাৰ হলো। মোৰ মায়ে ভোট দিছিল। 1971 চনত মোৰ দেউতাৰ ভাই ককাই 3জন দেউতাক লগাই। দেউতাৰ ভাই ককাইসকল হল মৃত জেফৰ ঢুকুৱা মনুষ্য মৃত নাছিল আৰু মোৰ দেউতাৰ ভনী হল মৃত চেৰাবজান দেউতাৰ ভাইসকলৰ মৃত্যু হিতেশ্বৰপুৰত হয়।
Now, once you look at the Jamabandi, you see everything which was lacking has all been filled up. In the Jamabandi serial number 1, 2, and 3, you see their uncles. Everything has been asked by the AGP, and then all the whatever blank was there, are all filled up. Had this been there, we would not have taken so much of time to understand. Even 99, everything was. The amount of disbelief you have, come to the cross-examination page 99 onwards, everything has been filled up. I was insisting that cross-examination is something which the government advocates and the APP should learn. Simply reason.
Meeting on last week, one meeting was held. One meeting was held on last week. Mr. Pine has since all these things regarding records of confirmatory reception.
No, that's okay, but I think there should be more sessions of the art of cross-examination.
Yeah.
Phase-wise, has to be done. Okay, send it back to it. Closing the matter, we pass the judgment, reserving it for others. Some delay. And Mr. Dev, we are well off without any assistance of the learned counsel. We'll save a lot of time. If we read ourselves, it will take us less time than taking the assistance of learned counsel and then hearing the matter.
So this document.
We find the assistance lacking. Mr. TKD, learned counsel to the petitioner, heard for the respondent. Submissions are concluded, judgment is out. Yes, item 3.
Item 3 for hearing.
There is no representation from the petitioner. All the respondents are represented. So it is made clear that if the default continues on the next date of listing, adverse orders will follow. List again on 26/8/2025.
Item 6 for hearing.
I'm sorry. 6. Lordship, the file we have has misplaced in our in my senior's sample, Lordship. So kindly give me a short date that we can find it. The petitioner is in time.
टी बेगम। कितनी आवला जज?
Item 7 for hearing. Item 8 for hearing.
Can you give possible for tiny sceneries of being?
Item 9 for hearing.
May I please? Insurance page, legal order page number 62 वाला. And findings वाला discussion and decision and decision वाला page number 64.
first voter list of your, of yours.
My lord. 97, my lord. That voter list is not annexed matter. In this voter list, mark was marked as D, my lord. My lord,
That is at which page?
my lord, page number 19, paragraph 14, my lord.
Page?
Page number 19. Amendment written statement, my lord. We start from page number 18, my lord.
No, no, your own voter list. Which page is that?
My lord, that voter list was not, is not annexed, my lord.
It's not annexed. 19?
My lord, page number 19.
No, no, your first voter list said is of which year?
That is not mentioned, my lord, at the first voter list or last voter list. There is no mention, my
No,
lord.
that's okay. You may not have mentioned it, but according to your evidence, which is the first voter list where your name appeared?
My lord, 97, my lord.
97, which page is that? Where is that 1997 voter list?
My lord, that voter list is not annexed, my lord. It is
Not annexed.
Yes, sir. Annexed, my lord. ये तो कैसे की बता रहे ये तो कमेंट कर सकते हैं ये कनेक्टर वन दिन की
You behind. We'll continue after lunch. Just look at the LCR. We have not been able to.
Yeah, please, Lordship. My lord, I am sorry, my lord, my item was 7, my lord. And my lord, I filed my Bakalatnama on 14 July 2025, my lord. Earlier council, earlier the sets of council was defined. And my lord, the copy of the petition and necessary documents is not available with me. My lord,
Which
while
item?
While the petitioner is
Okay. Your name is there in the cause list?
yes, ma'am. My name.
Uh-huh. Okay, you want us to record your presence?
Yeah.
Okay. Item 7. Not yes, sir. Earlier order, strike it out. Item 7, pass a fresh order. Both sides are represented on the prayer made by Mr. S. A. Ahmed, land counsel for the petitioner. List after 2 weeks.
Right. Okay. Obligement.
Yes.
Item 9.
Yes, ma'am. Page number 25, my lord. Photo list of mother and maternal grandfather. Father was died before, my lord, 1965, my lord. And mother, my lord, page number 25, my lord.
Yanta Mandal. Kalani Beva.
Felani Bro.
Okay. This is your maternal
Menda,
grandfather.
Menda Mandal is my maternal grandfather.
And this Falani Beva is your mother.
Yes, ma'am.
Yes.
My lord, page number 27, 1970 photo list, same, my lord.
Page.
Page number 27, my lord.
Yes.
Thereafter, my lord, page number 25, Gaon Panchayat certificate, that document is not executed, my lord.
Yes. Did Gaon Panchayat secretary come and depose?
No, my lord. My lord, Gaopura deposed, my lord.
My lord, page number 31, my lord. Exhibit F. Gabura divorced, my lord. This is only linkage, my lord. And my lord, oral evidence. Brother and sister, my lord, deposed before the tribunal. My lord, all witnesses cross-examined by the tribunal himself, my lord.
This page 31
My
is
lord,
the Gambura certificate. This page 30, there is a Gambura certificate. He came and deposed
my lord, page,
30.
yes, my lord. That document, my lord, this Gabura not deposed before the tribunal. My lord.
Did not deposit. Okay.
Gabura village Kudnabari, this Gabura deposed, my lord. My lord, all the witnesses cross-examined by the learned tribunal himself, my lord. And my lord, the all documents has not been discussed in the judgment and order, my lord. My lord, the Gabura certificate exhibit F has not discussed, my lord, in this order. My lord.
Mr. Sharma, can you send the records back for a moment? Tadi ko rasa po. Itu possible before the process. What is new process? Further evidence. Learned constant ready was present allowed for submitted further evidence. Present. Written as Swara Mandal, but a certificate copy of the voter list overridden. ঠিক আছে Yeah, I put proof করে দিছে to the original. It was 24/4/17. It was so. Please bring. Missing আছে missing আছে এটা নাই petition এটা petition নাই Twenty-four 417 3617 খুব হেল্প কৰিব কাৰণে petition দিব লাগিব ন 3617 3617 ঠিক আছে আমার ফার্স্ট গোল I really hope it's not a pretty place of there. It is contrary to your critics. Hmm. I'm in resistance. Me too. Me call. Pero mi automático le diría. Brother, vice. WS to the file code WS to WS to and allowed on This is it. That was the 47. My 25/7. I like it. 25/7. To cross. Expanse করবো নাকি সেটা middle is the cross. I will first to explain things. That is no longer there. It will also operate. Yes.
My lord, another point is, my lord, in reference, form number 7, SP report, there is mentioned the grounds of doubt. My lord, mentioned that ground of annexure B. At annexure B, there mentioned there is a doubt on the basis of annexure A. And my lord, annexure A, only the name and address fill up, there is maximum clause is blank, my lord. There is no opinion of the referral authority, my lord. Clause number 15 also, whether migrated into Assam, yes or no, there is no any mark, my lord.
Yes.
Page number 14, I think. On this point, my lord, I have relied on judgment, my lord. Rafika Bibi, yes, my lord.
Does it?
My lord, para number 27, 28, 29, 30, 31, 32, 33, 34.
Yes.
Lord, have relied another judgment regarding cross-examined by the tribunal, my lord. My lord, another decision, my lord, regarding cross-examination by the learned tribunal. My lord, para number 5, 6, and 8. Another judgment, my lord, on Jana Vishwas case. In this case, my lord, father deposed before the tribunal. His deposition has not been challenged by the state, my lord. In my case, my lord, my brother and sister, my lord, deposed before the tribunal, my lord. There are number 78, 79, 81, and 100, my lord. And 100, my lord. My lord,
What is the name of your brother who came and deposed?
yes, my lord. Qasim Ali, my lord. DWP.
Uh, Prior to this 2008 voter list, is there any other voter list of Qasim Ali?
My lord, total list of 2008 part of my lord. My lord, page number 32,
32.
32, total list of 2008.
Yes, before this, is there any voter list available?
My lord, only 2008 is available, my lord, is annexed with the reputation, my lord. Page number 30.
He was 48 years then.
Yes, my lord.
Yes.
My lord, another judgment regarding the statement of Gaubura has not been challenged by the statement. Para number 9, my lord.
Yes.
My lord, thereafter, on the point of my lord, discrepancy is name and age, my lord. Moti Rahman case, my lord.
Let me send it back to the.
Para number 11, my lord. My lord, on the same line, discrepancy in name and age, my lord. Rohim Ali case, my lord. Para number 42, 43, and 44, my lord. This is my submission, my lord, and may be declared the petitioner as an Indian, my lord. Okay.
Look, he has submitted. Look, he has submitted his WS. Let them get WS was amended. So if the amended WS is amended, we have to accept the second one. The old earlier is amended. So earlier WS may not have any value in after the amendment of the earlier WS. So we have to accept the second one. The which is by which it is amended. In fact, there is no provision of amendment of WS. I don't think whether there is. If I
You see, this matter would have to be remanded for two grounds. You have the records, they sent you the records.
Yes.
Down below, you'll find there are two evidence and two cross-examination. Two cross-examination we have flagged. Correct?
those were not considered.
No, no. Consideration is something else, but there is a fundamental error which has crept in. There is a well-established law that an affidavit cannot be amended.
Yes.
But here the tribunal allowed, there is an order sheet of 13/6/2017, which amendment was allowed.
13/6.
13/6/2017.
Written.
Correct?
Yeah.
Now, in that flag which we have put up, you will find that the amended written statement was filed on 14/7/2017, and the amended evidence was filed on 25/7/2017. And thereafter the cross came. Now, in the first, what the fundamental error which has happened is that there are two errors again. Number one, that the cross-examination, you look at the cross-examination. Now, it starts with cross through court.
Yes.
Correct. So once the tribunal starts cross-examination, it could have asked questions under 165. Instead of it, the tribunal starts cross-examination and therefore downs the rope of defense or prosecution. That is one fundamental error. The second is, you look at the first cross-examination. The question asked there were omitted, and in the second only few questions were asked related to his brother or something. These are one after the other. Two flags we have kept. Correct?
DW1.
Yes. So therefore, the tribunal proceeded in a manner that the first examination of the witness has been saved. Because you see, once you allow an amendment, the earlier document, just like you said, the earlier written statement goes. So earlier evidence also goes. So therefore, the cross-examination can't stay. These are the two fundamental errors which is kept in the proceedings, for which it has to be remanded back.
Let's submit that. But I have seen I've understood what your loss is. My submission is, my lord, in fact, even though, my lord, these are, yes, obviously, my lord, the tribunal has no right to cross, definitely it could not. But 165, it's a clarificatory nature, so they may clarify themselves. Now, in the entire, my lord, opinion, I have not seen, my lord, your lord, to make any control. These facts, my lord, whatever found in the cross, or my lord, 165, these were not material for my lord considering.
No, that will not even arise. The reason is, You see, in a case where there is a change of role, the question of prejudice will never come.
Yes, Malad, what my submission is, it's, Malad, definitely it will not be crossed. It is 165 in itself. That is my submission. Secondly, Malad, the main fact here, Malad, my learned friend is also arguing, Malad, you have saying that these documents were not considered, these things were not considered. Malad, definitely those were not considered. I have seen the opinion, Malad. But Malad, the primary fact is that whether his father was there in the India prior to 70, that fact is not established. When that fact is not established, the other parties, I don't think this, because my lord, the primary fact is his father, whether his fathers were there, that is the primary issue. If father is there, then only this will come, my lord, his linkage to that parent, father, and other all this material. Primary issue, whether his father was there, because under had the petitioner been there prior to 1970 in India, there was no issue, madam. Then all these things could have come. First of all, in this case, my lord, because his existence in India prior to 71 is not there, so he has to link himself through his father. So he has to prove whether his father was there or not. To prove that, my lord, he has only brought one document, which is dealt by the tribunal properly, madam. That NRC documents of 1951. That is dealt properly. That has been dealt properly by the tribunal. Once that is not there, if NRC document is not there, there is nothing, my lord. There is nothing to show that his father was there in India prior to 71. Then all other aspects, in fact, my learned friend is asking, my lord, that the document for the, if it is not, even though it is discussed, your lordship may kindly say page 29. This document is saying that this document is not considered, this evidence is not considered. Had it been considered, my lord, his case would have been gone to the spin. What is there? My lord, as per the affidavit itself, my lord, his date of birth is sometime 1955. What this certificate says? The petitioner got married on 2/8/1952. As per this certificate. I'm not coming to those points. Page 29. 29. This was not considered good enough for him, my lord. Had it been considered, do it 1952, got married. Had it been considered, my lord, the entire case could have done. No, these were not considered because these are, my lord, post 71 documents. This certificate was issued in 2015. And my lord, only because the tribunal wanted, my lord, whether his father was there in India prior to 71. If that fact is not proved, then others are immaterial, my lord, not relevant at all. Because he has not produced any documents of his existence prior to 71. There should be two aspects. Either his father should be there or he should be there prior to 71. First fact, that has to be proved. Then only other aspects will come. The NRC only document is NRC 1951, that is page 24. The only document relied.
Perhaps you'd like to change your mind, come to page 42.
Amendment.
Last paragraph, para 8.
This is too much. He has stated
Then
this,
para 9,
his father was there,
para 9.
enrolled in the voter.
And my lord, these two documents has not been exhibited, my lord, before the tribunal, my lord. The evidentiary fellow is
Exhibit one.
NRC
Thalani
details and
Seva and, yep. Para 9, it is them. Para 9,
Then para 18, page 3. 44, sorry.
yes, this is statement of them. I'm not denying that. Only thing, my lord, what my submission is that, my lord, he has brought, but I want to document whether the father was there to prove that the father was there in India prior to 1970. That must not. So what is the document? The only document they brought is with NRC 1951. And my lord, if we go to the NRC matter, this certificate was issued by the police authority, superintendent of police, who is not authorized to issue the certificate because it is the document of census. The 1951 my lord, NRC was made under the census act. So it is police cannot issue this certificate, first of all. So police, where from he got it? This is, and secondly, my lord, the honorable court, this honorable court time and again that say 1951 NRC document has no evidence value. This is the term. And fourthly, my lord, your lordship may kindly see the document on the face value of the document, page 24, my lord. This is to certify that name of Ninda Singh, son of so-and-so, is appeared in the NRC 1951. Holding number so-and-so, village so-and-so, Sadhanapatta so-and-so, under so-and-so, he is in the district of Borpeta with his family member. The petitioner is not family member of this Malat, this Munda Sikh. Munda Sikh is nowhere related to petitioner. Malat, father of the petitioner, projected father. The projected father here is Fazal. They are saying that this Fazal Fakir. In fact, it is different name in thereafter. Fazal Fakir is no more thereafter when they are claiming that their parent, his father. This Fazal Fakir, son of Osman, is nowhere related to this Munda Sikh. And my lord, I always say, my lord, statement they have given that my father, the father of the petitioner died prior to 65. That means prior to 65. When did that? It may be 55 also. It may be 1952 also. So if he died, my lord, just before 65, there could have some document along with the mother of my lord, any other people. If he died immediately after 1952, that's a different issue, my lord. After this NRC is enrolled, there is no more document can be accepted. This, there is no specific statement. Only statement is my father died prior to 65. It's a vague statement. Similarly, he has nowhere stated, my lord, when she got married. She got married, but when it is not there. All these things are vague. So if this NRC document is, my lord, not there, as per the, my lord, on the basis of the judgment of the Honorable Court in various cases, my lord, then where is the document of his father, her father, prior to 71? Then she has to prove that she was there prior to 1971. Where is that document? So that is dealt by the tribunal, my lord. That's why the tribunal has elaborately dealt with the, my lord, NRC document. Statement is there, those has to be proved.
Statement in WS.
Please repeat, what are the points you said? First is, you said the father's presence before 65 is not proved. What is your second
Before
submission?
71, madam. Before 71,
Hmm.
there is no document at all, except this NRC. NRC. And NRC, it is Fazal Fakir, not the Madam Fazal Ali.
And your second submission is?
Second conditions, and the this NRC is not valid because the police cannot issue this NRC certificate. The NRC 1951 was conducted under the Census Act, and it is the Census Authority who can issue this document. Thirdly, the NRC document is not admissible because by this, my lord, I'd like to cite this judgment for that purpose only. This is my lord Abdul Majid versus Union of India. In this case, 6090/2016. Abdul Majid, my lord. ABDUL Abdul Majid versus Union of India. Six zero nine zero 2006. So, Madam, if father's presence is not there prior to.
No, you said you had 4 submissions.
Yes.
One is this father's presence, then second is NRC not valid,
Yes.
Abdul Majid.
Yes.
Then
Madam, secondly, Madam, if father's existence prior to 71 is not there, he has to prove that he was there prior to, he was there in India since 1970 or prior to 1970. Because the cut of that is 25 March 1970. Either one, he has to prove that either his father or he is there in India prior to 1970. Then if father's existence is there, he could have proved for linkage documents, not other linkage. So if the father's existence could not be proved, the other linkage documents are not relevant at all. Like the NRC process, my lord, there is a document, primary document, which has to be linked to other document. So the primary document is not. Primary fact that his father was a citizen of India, that is to be proved first. That is not. So if it is not there, the other thing, because that the tribunal has not discussed all other things. No one, something my learned but something I'd like to point out clarify because your lordship has also dealt that matter with. So he has said that in the
Speak loudly, you're not missing a voice.
My lord, my learned friend has argued that in the Annexure B, that is local verification officer's report, there is nothing. So the reference should not have been made. That I have argued again and again, my lord. In the 1997, my lord, these are the cases, my lord. 1997, the Election Commission guideline, it is clearly said that once the ERO, my lord, doubts the presence, the citizenship of the person in the 1997 voter list, because his name may have been appearing in this 1997 voter list suddenly. Though ERO direct and local verification officer. LVO is not a person from my lord election office. He's an independent person. So direct the LVO to make a verification as to whether the person's name can be continued in the voter list or not. The question is that only, whether his name can be continued in the voter list or not. If the ERO is satisfied with that report, you'll continue to name in the voter list. If ERO is not satisfied with that LVO report, he has no option but to send the matter to the Foreigners Tribunal for my lord determination. Now, if LVO report doesn't contain anything, now the tribunal the ERO has to send the matter for tribunal for verification. If my lord LVO report contains everything and some documents which can be relied by the ERO, then ERO would not have sent the matter to the Foreigners Tribunal. He could have dropped it and he could have continued the matter, continued his name in the voter list of 1997 and thereafter. So ERO report is against them on. If in ERO report they cannot provide something, because ERO used to, is the duty of the ERO to LVO to go to the house and make verification and collect document. These are the materials to be collected by LVO from the person. If he doesn't provide anything to the LVO, what the LVO will give? LVO will give a blank. If LVO give a blank report, ERO has no alternative but to send a matter to the Foreigners Tribunal. That is the law. That is settled. So
The submissions of
My lord, one thing, I have one, my lord, page number 24, NRC details, my lord. Mendaseke is my maternal grandfather, my lord. These documents has not been exhibited in the tribunal, my lord. And my lord, page number 29, GP certificate. This is also, my lord, not exhibited before the tribunal. So, my lord, there is no evidentiary value in these two documents, my lord. That's like.
exhibited no. Exhibited no.
Exhibited নাকি? না জাজমেন্ট তো করে না কিন্তু এই জাজমেন্ট যখন করছে জাজমেন্ট তো আপনার এনএক্সার বলি আছে
ও
এনএক্সার ও এনএক্সার বলি আছে
Yes.
এই এক্সিবিটেড ডকুমেন্ট
Then it is probably the exhibit 19 the NRC was not accepted because it was a Xerox copy. So it could not be accepted. Yes. The NRC document is taken as annexure.
If you come to page 24 of the petition.
Yes.
This is the NRC.
Yes.
yes
I find FP case number 340 of 2000 something.
Yes.
Exhibit A.
Exhibit A.
yes my lord
It is written as exhibit A.
they are mentioned my lord but my lord
signature
in the
member is not there.
in the order there is mentioned my lord annexer only
So,
page number 66 my lord
my lord, this is the procedure in trial court in tribunal. So this is normal procedure. My lord, generally advocates they give the my lord annexure mark. Thereafter, the tribunal has to sign it. There is no signature is there.
no, let us understand. Yes,
page number 66 my lord
yes.
only NRC of 1951 mentioned only annexure, my lord,
Annexure.
Okay,
This is not exhibit.
not exhibited, my lord.
okay. But the Gaon Panchayat certificate is
Gaon
exhibited.
Panchayat certificate is
Yes, my lord,
Exhibit B.
my lord, Gabra certificate is
Like
two,
Gaon Panchayat.
two
Gaon
certificate, my lord. One Gabra certificate is exhibited and my lord deposed before the tribunal.
No, no, Gaon Panchayat.
No, Gaon Panchayat.
No.
Page 29 is Gaon Panchayat.
Yes, my lord,
Gaon Panchayat
Gapan certificate is not exhibited, my lord.
Exhibit, that's not. Exhibit.
Exhibit D.
Exhibit
You
D is
come to page 65.
My lord,
Exhibit D.
yes. My lord, in the order, my lord, exhibit, yes, my lord, sorry, very well. Sorry,
It's not proved in accordance with law,
yes, my lord,
but it is there.
yes, my lord.
And NRC is, of course, my lord, not exhibited, exhibit was not.
Submissions of Mr. N. Hussain, and counsel for the petition.
M. Hussain, my lord. M. Hussain, my lord.
M. Hussain, I'm sorry. M. Hussain, and counsel for the petitioner. This is J. Pang, Mr. P. Sharma. So I concluded, judgment result.
Most of present.
There is a single bench I have to take up. That rise, some discussion to make in this case before we formulate. Other matters will be adjourned. Is it the same? Item number 1. John लिखना. Huh? Item number 1 is adjourned. Would please put it there. Item. The students are there behind you. You are able to follow anything? Yes, come forward. You both have been sitting in court. You have been able to follow anything?
Yes.
Yes. If you have any queries, you can ask Mr. Pang, he's here. If you have any queries. Correct. All sides are represented. Like as the informant has appeared through a learned counsel, of whose matter this bench is unable to take up in view of notification number 49 dated 27/6/2025. Let this matter be listed before any other bench without me. K.R. Banaji. Okay. Next, as the Next, Mr. P.S. Lakar, APP has submitted that he has received the case diary. Next, in view of above. And considering that the case diary is available, list the matter on, make it, this will be 11/8/2025. Today is 8th. Oh, sorry, today is 7th. Tomorrow there will be some disruption in the bench. 11th. The case diary will be retained till then. Monday. Once I can't take up, I can't take up. So once the case diary is there, we are not adjourning it. The investigation will stop. The interim order stands extended till the next date of listing. Yes, you are saying something? I didn't get it. Please repeat again. Okay, has the Vahatma gone there in this section? Okay, it has been submitted that for the petitioner, Mr. T.J. Montar and senior counsel is leading the matter. Accordingly, the registry shall examine if the Vakalatma is filed, the name of Mr. T.J. Montar, senior counsel, shall be reflected as reflected in respect of the petitioner while listing the matter next. You were saying something? Well, case diary is available. We'll be holding it for 6 days. Any difficulty? The court master will get some information. Just hold on. Yes, item 1. The notice served on respondent number 2. Nobody has appeared. Petition is available, no? For the second consecutive day, the petitioner has remained unrepresented. In view of default of the petitioner appearing in the matter on 12/6/2025 and today, I 7/8/2025, court is of the constitutional opinion that the petitioner does not want to pursue this matter, and accordingly, this bail application stands closed, having not been pressed.
Two with three.
Okay, no representation from any side. For end of justice, the matter stands adjourned today. Just after a week. Okay, then we are listing it tomorrow. We are on list on 8/2025. Since the case data is available, we don't want to stall the investigation.